the legal responsibilities of the organization, from filing to notifying clients. Please note that this is legal information and not legal advice. Every situation is unique and you may have additional reporting obligations. You are more than welcome to use our free Personal Information and Electronic Documents Act Breach Report Generating tool to create the necessary forms. We recommend that you seek the advice of a legal professional to see if you have any additional reporting requirements. That being said, let's have a look at the relevant pieces of legislation. The Personal Information Protection Electronics Document Act is a piece of federal law that sets national standards for privacy practices in the private sector across Canada. All businesses that operate in Canada and handle personal information that crosses provincial or national borders while carrying out commercial activity are subject to the Personal Information and Electronic Documents Act, regardless of the province or territory the company operates in. In the event of a privacy breach, businesses are required to do three key things. First, businesses must report breaches of security safeguards involving personal information that pose a real risk of significant harm to individuals to the Privacy Commissioner of Canada. The law provides the following factors to determine real risk of significant harm: the sensitivity of the personal information involved in the breach, the probability that the personal information has been, is being, or will be misused, any other prescribed factor. Second, individuals affected by the breach must be notified of the breach. And finally, the business must keep records of all the breaches. The Privacy Commissioner of Canada provides information on breach reporting online. Let's look at each of these requirements in a little more detail. Reporting breaches to the Privacy Commissioner of Canada. The law requires that you must report any breach of security safeguards involving personal information under your control if the breach could create a real risk of significant harm to an individual. It does not matter if the breach only affects one person or if it affects 10,000 people. If there is a real risk of significant harm resulting from the breach, it must be reported. Reporting can be done using the Personal Information and Electronic Documents Act Breach Reporting Form. This form can be easily filled out using our free tool. Notifying individuals. The law requires that individuals affected by a breach should be notified as soon as possible after it has been determined that the breach poses a real risk of significant harm. The notification must include enough information to allow the individual to understand the significance of the breach and the recommended steps they should take to reduce the risk of harm that could result from the breach. The notification should include information such as a description of the circumstances, the day the breach occurred, a description of the personal information that was the subject of the breach, steps that the business has taken to reduce the harm of the breach and recommended steps the individual could take. And finally, contact information should the affected individuals want to obtain additional information. Individuals can be notified directly by telephone, mail, or email. Indirect notification can also be used in these limited circumstances. If direct notification would cause further harm to the affected individuals, if direct notification would cause undue hardship for the business, or if the business does not have the contact information of the affected individuals. Keeping records of all breaches. The Personal Information and Electronic Documents Act requires you to maintain a record of all breaches of security safeguards of personal information under your control, regardless of whether the breach poses a real risk of significant harm or not. The records must contain information that enables the Office of the Privacy Commissioner to verify compliance with the reporting and notification requirements outlined in the Act. At minimum, the record must include the following information: the date or estimated date of the breach, a general description of the circumstances of the breach, the nature of the information that was breached, whether the breach was reported to the Privacy Commissioner of Canada, and if individuals affected were notified. It is important to note that it is an offense to knowingly contravene the Personal Information and Electronic Documents Act's reporting, notification, and record-keeping requirements relating to breaches of security safeguards. Doing so could lead to fines.